Hi, it's Christine Faulkner with Cava and Faulkner, Elk Grove Estate Planning Attorney, and we're here for another edition of Family Matters.
Hi, I'm Lana Shearer, a family law mediator and attorney in Elk Grove, California. Happy to be here for another session with you, Christine. Today I have some questions. And so in family law, we have a lot of blended family situations. I have a couple that may have been divorced previously and then get remarried. Sometimes that second marriage may end in divorce. But from an estate planning standpoint, how do you handle if one couple is divorced and in the first marriage they had a couple of children together, and then they get remarried to another spouse and they may have a child or two together, or may have adopted the existing children in that relationship, but in their estate plan they still want to leave a part of their estate specifically to their children from their first marriage. It's not a family law, we don't address this in family law at all. It's really an estate planning matter, but I do have questions about that when we're doing the divorce process. So how is that handled in estate planning?
So there's a bunch of different ways that you can handle that. So the first and the easiest way, obviously, is to, well, it's probably not obvious, is to leave a specific monetary gift or gift of property to your children after your death. So, one of the questions I ask my clients, my married clients, is, do you want to make a gift of either, money to anyone other than your children? And that's in the usual sort of family, where they have children from that marriage. Do you want to leave a gift of money to anyone? So any of my either parent could say, yep, I want to set aside a specific account, or I want to set aside a specific amount of money or a piece of property. So we definitely can create the plan that says, this piece of property, especially if it's separate property, if it was owned before the union, I want to leave that property to my children from my first marriage after my death, whether I die first or whether I die second. That specific series of gifts just go to my kids.
Okay, I think a concern, I think a concern may arise sometimes when you're remarried and, now you're creating community property with your new spouse. I think sometimes there's a fear perhaps in one party who have children from another marriage to make sure that, they're gifting a part of their estate to their children and it's not all going to their new spouse. So you're saying the best way to avoid that of things going to the new spouse because it as community property, to make specific gifts of specific accounts or specific property to those children.
Yeah, so that's one way. And certainly with beneficiary designated accounts, so any account that may have been acquired before the marriage. And obviously it gets complicated and it really depends on, how old these people are, right? Because you can have an account that was owned before marriage. And then of course, if there's no prenuptial and they're still working and there's contributions to that asset, then it gets a bit dicey. But in California, generally you can't leave your retirement account to anybody other than your spouse unless they sign off on that. And so that can get, if you kept that account separate, right? If the client kept it separate, started a new retirement account after marriage to use community property to fund that account and named the surviving spouse, but kept the prior retirement account, the one that was owned before marriage and funded with premarital dollars, the spouse could now leave that asset to their children through a beneficiary designation without having to get the spouse's approval. So part of it is kind of like what we talked about last time about not commingling, right? And the dangers of commingling. Because regardless of beneficiary designations, there can be a claim by the spouse if there's community property that funded that asset, right? And then
Right.
there's been a circumvention of leaving the asset to the spouse. So it can get very, very dicey, right? So that's why not commingling is so important, especially after a remarriage. Really, really probably talking to a financial advisor and having these conversations with their family law attorneys about how do I make sure that I'm keeping this property really separate, because if I do want to leave it to my children from my first marriage without there being a claim, how
Right.
do I do that?
Yeah, and keeping
So,
it separate is definitely the best way. It's the only way to completely ensure is keep it completely separate. But if earnings, if earnings after marriage go into that account, you're right. It starts, creating some community property. With regard to long-term employment, I know, like if you're a state employee and you've been there for 20 years, and the first 10 years perhaps was during your first marriage, second 10 years, to make it easy, was during your second marriage. Hopefully there was a quadro, that qualified domestic relations order that divides that account for that first 10 years, that is clearly, divided with someone else, and your beneficiaries, should you pass, and your interest in that account would go to your children from your first marriage, if that's who you have as your beneficiaries. But what if there is no quadro? What if that was all just confirmed to that one party in the divorce, and then you get remarried and contribute for 10 more years? So, that's where it becomes, you're right, dicey. So I would imagine having it very clearly set forth in your estate plan about what portion of that is going to your children from your first marriage and what portion is going to your new spouse or current spouse.
yeah. So, beneficiary designated accounts, you can name your children as beneficiaries. If it's a specific account or accounts that are, say, bank accounts or investment accounts or a piece of real estate. Again, all of those provisos that we've just talked about, the idea being they're leaving their separate property, that the surviving spouse won't have a claim to it. Because there hasn't been community property, or the couple is already retired, right, by the time they're married, or they've never commingled anything, right? They just kept everything separately, regardless of who's living in the house. Everything's paid off by the time they get married. I see that, and so that obviously makes it much cleaner to be able to say, hey, I'm going to leave these specific accounts through my estate plan, and I'm going to name them in my estate plan, right? My Chase account or my investment account or this property. Those assets are going to my children. And so that's the first way, which is very straightforward. And it can be, like I said, financial or real estate, monetary assets or real property or personal property, of course. Another way is to divide the property at the first spouse's death. And so each, so the trust is divided into the survivor's share. So the survivor's half of the community property, and any separate property that the surviving spouse owns goes into the survivor share. And the decedent's share, and their half of the community property plus their separate property, goes into the marital trust. And then there's a number of ways that trust can be designed. It's a favorite of blended families when when the new spouse hasn't adopted the children. They do have children from separate marriages. They each want to make sure that there's something left for those children. So there's this separate share that has the deceased spouse's separate property and their half of the community property. And you can design that in such a way that it can be available for the surviving spouse if it's designed that way to take care of the surviving spouse first, but then to ensure that, and it is irrevocable. It's an irrevocable trust. It has a separate tax ID. So unlike the survivor's share that can be modified and changed, the marital trust cannot be modified and changed. So you can allow the surviving spouse to be the trustee of that trust, meaning the person who is managing the assets, making decisions about how the assets are invested, used, etc. Or you can say, no, I'm going to select a third party trustee for that share, so the surviving spouse will not have any access to that money. The third party trustee can dispense money to the survivor if he or she needs it. But the idea of not allowing the surviving spouse to control it is, well, I think it's fairly obvious to not give the surviving spouse the ability to dip into that money, to make sure that a disinterested third party is managing the money, to make sure that when the survivor passes away, that share will have been maximized to the greatest degree possible, hopefully not used at all. And then when the survivor passes away, it's been invested and it can be designated for either all of the children or just the decedent's children from the first marriage. I think, that kind of depends on if this couple now has children of their own as well.
Right.
But they can also, we can also design the trust to leave unequal shares, right? So if the deceased spouse has, say, a big amount, a rather large amount of separate property that they bring to the marriage, and that goes into that marital share. And it's kind of commingled with both community property and separate property, or maybe it's all separate property. They can decide, well, what percentage of that marital share goes to the children from the prior marriage as compared to whether they have children from their joint, their union, the second marriage. So, it doesn't have to be, if there were 4 children, it doesn't have to be equal. It could be, 80% to the children from the first marriage if there were 2, and then, 10% to the other 2 children. And then, of course, money would also presumably be coming from the survivor's share to the children from the joint union. So there's ways that you can equalize that, and it really depends on what the assets look like, how many children there are. And it certainly gets more complicated if it's a second marriage and they have kids together, right? Sometimes they each bring kids to the marriage and then they have children together.
Yeah.
I've actually seen clients say, we're creating a joint trust and we want actually most of our assets to go to our child or our children from our union, because we're combining our assets. And most of my clients really do, and I think I said this on a prior video, that most of my clients really do take the position that everything is community property. We're married, we're putting our lot in together.
They do that when they're creating their joint estate plan, but that changes when they want to file for divorce. It inevitably changes.
Yep. And so, we also discussed the fact that I don't create any kind of marital property agreements. I don't do transmutation agreements. There are the schedules attached to the back of the trust that allow people to list their community property and also their separate property. So it's a way to segregate, or at least be clear about the creator's intention, what they believe to be their separate property. I mean, as you know, there's more to it than just writing it down on a piece of paper. You can't automatically transmute property into separate property just because you write it on a schedule. But it does tend to show intent of the parties that they believe that this is their separate property. And hopefully it's an easy way to trace it, that there's no dispute. Yep, there's agreement. It was always the person's separate property. So there's not going to be any claim, and it'll be distributed the way it was supposed to be distributed. But creating that AB trust or ABC trust structure, which is a survivor's trust and the marital trust, is a very common trust structure that allows any party to a marriage to be able to allocate their half of the community property and their separate property to a separate share, and to make sure that they are able to leave something to the kids from their first marriage. And it gives both parties an equal footing to do that, and also protect it from remarriage. So if the first spouse passes away and the survivor remarries, it's another way to keep that away from the survivor's personal, their own property, which is not asset protected. And of course, it can be commingled, like in every marriage. So it's a nice way to segregate that property away to protect it from commingling and to be lost in a second or third marriage after the first spouse dies.
Right, which is the risk, which is why you can't do nothing. Not doing nothing is always the worst results, because you hear it all the time with a second marriage, third marriage, where no trusts were created and someone passes away and everything they have goes to the new spouse without any regard necessarily to the children, or there'll be a lot of litigation about it. And it's just, if you can have control over that and outline a plan just like you described, it sounds like they're easy to do. I mean, and they're extremely useful to protect for your children. And doing nothing is not the answer.
I have I've spoken to some folks recently who are divorced, and you know this too. The drive is so strong at that point it's like, no, we need to revoke this plan, and we need to do this as soon as possible. Now that we've, finished with the divorce process, want to make sure that nothing ends up with my ex-spouse, or that they have any kind of control over my either my assets or in my incapacity planning, because usually they're named as the primary agent. So want to get them off as quickly as possible.
Right. Yeah, there's certainly a list of things you need to do as soon as your divorce is final. Change your beneficiaries, look at your estate plan, create a new one. But with blended families and a second marriage, there's also a list of things you should be doing to make sure that you're protecting your assets if you have biological children from your first marriage. You have to take action, because there's no guarantee that just because something existed at the time that you got married to your new spouse, that it won't then just go to your new spouse and not to your children. If you want that result, you want to leave something to your children, you have to create a plan.
Yeah, absolutely. And I've seen beneficiary designations that didn't get changed, and so they go to the ex, or they have these very, very unintended consequences. And it's very sad when that happens, because people work their whole lives to contribute to retirement plans. They buy insurance, and they have specific ideas for how, who the beneficiaries will be. And it's that one little thing about going back and updating it that people tend to forget about. And it can have devastating consequences. I've seen it happen. I've had clients, not with work that I've done, but who have come to me with that situation, and it was really heartbreaking.
I have a friend who works for an agency who handles administration for pensions. And that's a call that they field often, where someone passes and they never change their beneficiary. And what do we do now? We never had the quadro, prepared to divide the account, and the beneficiary is someone else. And it has some some very sad results.
So tell me about the quadro. How does that work? And to divide accounts that could be, later considered community. How does that work?
So, the pensions, retirement, qualified plans require a special document in order to divide those accounts. And it's called a qualified domestic relations order. And the community property portion of that account, when you decide to divorce, the community property portion of that account is from your date of marriage to your date of separation. It's a community plan. You may have been employed prior to that date of marriage, and you may still be employed by that employer. But that community property portion, we want to divide that. And that community property is one half, the spouse, the employee spouse, one half, the non-employee spouse. So the specialized document, a quadro is what we call it, has to be filed with the pension plan and tells them how to divide that account. couple of different ways. You can leave all the funds in there for the non-employee spouse, and then when the employee spouse retires, they will pay out the share to the non-employee spouse. So you have to wait till retirement, or you can actually separate that account entirely, withdraw the non-employee spouse's portion and put it in a separate account that they can manage on their own. It becomes their own property, and it depends on their retirement, when they elect to retire and begin to draw the funds out. So, but if that document isn't filed with the plan, it never happened. It just didn't happen. So let's say you're divorced and you're divorced for 10 years and the employee spouse is remarried, and their, of course, beneficiary is going to be, listed as their new spouse, we hope. But sometimes they don't change it to their new spouse. It has happened. They don't change it at all. They just don't necessarily want to deal with it. It's a detail they just didn't think about. So they're married for 10 years to the new spouse. They pass away. No quadro has ever been filed. No beneficiary has been changed. It can all go to the first spouse. The whole thing can end up going to the first spouse because that's the beneficiary.
Yeah.
Or another unintended consequence is, all of it could go, if no quadro was filed to divide that plan, but we know that part of it should have gone to the former spouse, the beneficiary is changed, and then the whole plan goes to the new spouse, with the ex-spouse not getting their portion because they never filed that paperwork. So lots of unintended consequences if you don't follow through and do what you need to do, which is make sure you divide accounts close in time to your divorce. Don't wait and put it off and say, oh, I don't want to deal with it now. I'm so happy to have the divorce over. I don't want to deal with the details. It's not a detail. It just, if you don't divide it, it had never happened. You need to divide it close in time to your divorce. Same thing with doing beneficiary designations and creating your estate plan. If you don't create your estate plan, it never happened. Anything could go wrong. So it's really sad. It's a very, all of my clients, we hopefully get them done right after the divorce is final, and some of them before the divorce is final. You don't have to wait for your judgment necessarily to do a quadro. You can get a court order to have the quadro completed. Highly recommend it.
Yeah, that's really interesting. That I can't imagine why wouldn't people do that?
Sometimes they're really tired of dealing with attorneys and court and dealing with the divorce. So to them, it seems like a minor detail. It's not a minor detail. It's a really significant detail.
Yeah.
If you don't get it done, it hasn't happened. And we don't know when our time is up. We don't know when we're going to die. I need to get it done right away.
Yeah. Thank you for sharing that. Because that is, of course, a really important point, when working with people who, I work with a lot of people who are divorced and then they create a single plan, right? So they don't have the remarriage part of it, but certainly I have created plans for people who have been remarried. And I have to imagine that they did all of that. I'm talking to them about their beneficiary designations as part of creating the plan. But so important to the whole point of all of this, I think, on my end, and I imagine to a large degree in what you do as well, is to help the clients get the outcome that they want and have control over, especially when it comes to the assets, have control over who's going to receive them if they pass away and they haven't been used or enjoyed during their lifetime, if there's remaining.
Yeah, but not doing anything is never the answer. So it's just action. Take those steps. Super important. And the only way you're going to make sure that your intentions are carried out, both when you get a divorce and divide assets and when you're planning for your children, is if you take action.
Yep. So yeah, those are a couple of ways in estate planning where, you can either gift, kind of not outright, but carve out some specific gifts for the children, or create that AV trust structure that allows the decedent to really carve out that share put it into an irrevocable trust. Can be managed, not always, but can be managed by a completely third party to make sure that the surviving spouse isn't dipping into it, and as much of it is reserved and hopefully growing and invested well to leave, once the surviving spouse has passed away. So those are really common planning techniques.
Okay, well, I appreciate that. Thank you very much. And I think that'll be really helpful for my clients as well, because, we deal with remarriage a lot, and it's important. Yeah, thank you.
Yeah. So we wanted to say thank you so much for tuning into our series, Family Matters. We've had such a good time learning about the crossover between what we do. And thank you, Lana, for joining me to do this. It's been really informative. And
Yeah, thank you so much for having me. I've really enjoyed it, and hopefully we can, do it again in the future. And I appreciate it.
yeah. So we are going to be saying, bye for now. We may ramp up again as the year progresses and bring on some more interesting topics in Family Matters. But I wanted to say that if you do have an estate planning issue, you have questions, please don't hesitate to reach out to my law firm, Cava and Faulkner. 916-685-1225 is our phone. Cava Faulkner, cavafaulkner.com is our website. You can go check us out. And if you're watching this, you're probably either watching it on YouTube or on, Facebook or whatever. So check out our other videos if you haven't already done that.
Yeah, and if you have any family law matter questions at all, mediation, I also do litigation coaching. Please reach out to me. My website is sheerlawandmediation.com. My phone number is 916-226-1305. I'd be happy to help. And yeah, please reach out.
Okay. Well, thank you again so much, Lana. It's been great. And I really feel like I've learned a lot, and I think our audience has probably learned a whole lot as well.
Yeah, I think it's been really informative. And then if anyone has any ideas of things we might do in the future, they should leave some comments and tell us.
Absolutely.
It'd be helpful.
Absolutely.
All right. Thank
Okay.
you so much.
Bye.
Bye.